Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Hello, everyone, and welcome back to the Triage. In this week's episode, we're covering the 2021 340B outlook, something we touched on in our 2021 overall healthcare outlook, but wanted to do a deep dive today with myself. This is Richard Church, who does a lot of work in the 340B space, but also one of our other 340B experts, Andy Ruskin, who I'll let introduce himself.
Thanks, Rich. Yeah, this is Andy Ruskin. Great for me to be working with you, Rich, to collaborate on a lot of these 340B issues. And you and I always seem to have a lot of fun with these things.
Yeah, absolutely. It's been a great collaboration. So as we start and think about 2021 and what to look for in 340B, obviously you do have to set the stage with, what was a somewhat surprisingly dramatic 2020 with a tremendous amount of activity in the 340B world, notwithstanding that we were also in the middle of a global pandemic. So we thought it might be helpful to kind of start, Andy, if you could just set the stage for, what happened in 2020 that we now will be seeing the fallout and looking for what happens next in 2021.
Yeah, sure. That's a really good point, Rich. I mean, in 2020 itself just reflected the culmination of, I think, some tensions that have been in the program for even longer. And we're going to talk about a couple of these tensions in the way that they've sort of clashed and just made the perfect storm. One of those tensions being HRSA's continued pathway towards becoming much more laissez-faire due to the fact that they've had their hands slapped more than a couple of times in federal court because they don't really have regulatory authority other than in very circumscribed areas under the statute. And you combine that with this realization by manufacturers that what they call the gross to net, meaning the amount that they charge versus the amount that they realize on each unit of product that they sell, is being largely attributable to 340B, which now apparently has overtaken Medicaid in terms of being a downward pressure on the bottom line. And those two things coming together, naturally, the result is going to be that manufacturers are going to be looking for opportunities to question where HRSA has perhaps overstepped its very self-admitted limited bounds. And so what we've seen happen over the course of the past year is a lot of manufacturers where everything had seemed to have worked pretty well between manufacturers and covered entities for a very long time, an uneasy truce, if you will. This past year has been somewhat more of a bit of a food fight. A number of manufacturers have basically taken steps that carve back utilization in the world of contract pharmacies. And so the way that the manufacturers have been trying to limit the extent to which this contract pharmacy relationship is being used by covered entities is they tried two different approaches. In one approach, they had requested that hospitals provide data regarding all of their contract pharmacy utilization to the manufacturer through a third-party vendor to the manufacturers. And then a separate group of the manufacturers went a step further and they said, we are interpreting the ability for HRSA to set a contract pharmacy relationship more limited than HRSA has, and we will only honor contract pharmacy relationships where the pharmacy is actually the designated pharmacy, whether it be an owned or affiliated pharmacy or a specifically designated pharmacy for a particular covered entity. And this widespread use of multiple contract pharmacies will no longer be tolerated, and we will not honor requests for sale at the 340B price when these other pharmacies are purchasing drugs on behalf of the covered entity. In all likelihood, by the way, the reason that we get the first set of manufacturers that are merely requesting data is because manufacturers are then going to use that data to go get up to the PBMs, the pharmaceutical benefits managers, and say, look, you told us in our contracts that you were not going to charge us twice for the same utilization. So here's the data that shows that we've been paying rebates to you on the one hand and giving 340B pricing to the covered entities on the other. And so the goal for the manufacturers is to say one or the other, but it can't be both. And then, of course, when they're actually just cutting off the scope of who qualifies as a contract pharmacy, obviously that's just engaging in self-help. But what would you say, Rich, are some of the major trends that you've seen, or the breakdown in between manufacturers using the data requests on the one hand versus the limitations on who can be a contract pharmacy on the other, in terms of which model seems to be more popular?
Yeah, well, it was interesting, I think, because so many covered entities just essentially uniformly refused to produce the data. That strategy did seem to struggle as compared to, just the kind of unilateral cutoff. But, across the board, I think what we now see as we come into the year as a major thing to watch is the fallout of all of this, which was a couple of key things. One, HHS ultimately did step in and say they thought that the manufacturer's actions were inappropriate in an advisory opinion that was very strongly worded. Litigation was filed in in many venues, also in many guises, that is, now ongoing. And in the midst of all of this, interestingly, the Trump administration pushed out the ADR rule, which was one of the remedies that hospitals and health systems and other covered entities had asked for as a pathway to have an enforcement model. So they did push out the ADR rule, which means there is now a pathway to do alternative dispute resolution if you don't get 340B pricing you deserve. And, and immediately a number of provider organizations, particularly at the FQHC level and other grantees, started those ADR actions. So that creates, a tremendously complex landscape of federal litigation, ongoing ADR, and a big open question now about what the new HHS Secretary Becerra will do, in follow up to the advisory opinion issued by the outgoing administration. So with that, maybe tell us what you think does happen as those things play out in 2021.
The first problem has not been cured, and the problem is that HRSA has no authority. The ADR rule was one of those few places where HRSA has expressed rulemaking authority. The hard part is what happens when HRSA has the ADR authority, but it doesn't have the authority to really set policy. So the ADR process becomes an effort in adjudication, where they're going to issue a ruling and they're going to say, you're right, you're wrong. And by the way, the ADR process allows for trade associations to step in on behalf of a class of plaintiffs, either on the manufacturer side or the covered entity side. And so you could have a trade association come in. You could see how HA and Pharma are basically duking it out in front of HRSA, and HRSA is going to issue an opinion. Whatever HRSA says, however, is ultimately going to end up in federal court. Becerra, the nominee for Secretary of HHS, had acknowledged in his hearing that ultimately whatever the outcome is from ADR is ultimately going to be something that could be challenged in federal court. And so really what's happening now with all this litigation, HA has already been dropped from one suit because it was deemed that it was not right because they were supposed to go through ADR. And what we'll probably see is that Pharma as well is going to be channeled through the ADR process, is essentially that we're just going to delay the inevitable, which is that we're going to be back in federal court to try to figure out then whether or not whatever the outcome is from ADR was correct. Chances are, given that we have this advisory opinion that you just mentioned from Bob Charo, the former general counsel to HHS, that Becerra has said he wants to build off of, it is in all likelihood going to be that HRSA rules in favor of the covered entity community when it comes to the contract pharmacy issue, but then it's going to go to federal court. And the issue will really be at that point, well, what exactly is HRSA able to do? Did it have the authority to issue a rule with respect to contract pharmacy? And this is going to start to sound a little bit wonky, Rich, but the way that will ultimately play out will be a question as to if it doesn't have rulemaking authority, whether or not it has something called Skidmore deference, which is an Administrative Procedure Act concept, which means if an agency doesn't have the ability to issue a rule, does it otherwise act reasonably and persuasively? And so what's going to happen during this next process when we're at the ADR level is HRSA will create a record. It's going to issue a determination. It will largely say what Charo said in his advisory opinion, which Becerra, even though he's from the other side of the aisle, has already championed. And then the question will be whether or not that is a more reasonable argument than the argument that pharma is likely going to present in an ADR process as to why HRSA does not have that authority, why the statute does not allow for contract pharmacy utilization to be replenished under the 340B program. And a federal court is going to ultimately be deciding this anew. And so there's really no way to predict what a court is going to do once it examines that record, given that the deference that one ordinarily thinks is given to an agency will actually not truly be given here. There may be a plus, but it's certainly not going to be the test of we uphold what the agency said unless it's wholly laughable. So we really cannot predict what's going to happen. That action is likely not going to occur for probably 9 to 18 months. My guess is that the ADR process will probably kick off in another 3 to 5 months. It will probably take another, given the speed that HRSA generally acts on these types of even nuclear issues, it's probably going to be the end of 2021 before we see anything. And then it's probably going to take another year or so for this to mature in court, is just my guess.
I'm sensitive to where we're at on our time here, so we will probably come back for a second edition at some point this year. Certainly, this issue will get a lot of headlines in 2021. If the start of the year is any indication, I think the other issue we'll continue to talk about substantially in 2021 is reimbursement of 340B drugs and potential action by payers and PBMs to impact that negatively. There's already been quite a bit of activity there. And interestingly, again, dovetailing into this legislative conversation, in a post-Rutledge world where arguably states can regulate PBM pricing related to ERISA plans, a lot of activity as well at the state legislative level to address PBMs that may be reimbursing 340B drugs at a lower rate. So I think we'll save that as a preview for our next update on 340B, but certainly another major topic to watch in 2021.
Thanks again for listening to Triage, timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.